Caseworker.
Gonzalo Rios, attorney for the child.
Deborah Wilson, CPS supervisor.
Carol Beimer, investigator.
Todd Simons for the mother.
Ready for respondent father.
Let the party know we did request for Mr. Craig Funk to appear today. He is in the Tom Green County Jail. We received this message this morning from Deputy Hector Lopez. Mr. Funk is stating that he does not want to attend this morning's CPS hearing. They sent him back to housing as he did not want to attend the hearing this morning, but we did offer him the opportunity and he has refused.
And Judge, I'd like it on the record that that's consistent with our attempts to communicate with him as well. And therefore, I have not had an opportunity to prepare with the help of my client now for the last month and a half, 2 months. So I'm prepared to pursue this, to go forward, but without having had any help from my client. So it's where it's at. So I guess I'm ready to the extent that I can be ready without the assistance of my client.
All right, thank you, sir.
Your Honor, I would also like to put on the record, apparently one of my witnesses who was duly and properly subpoenaed just logged off because the judge in the criminal case does not want probation testifying in this case, which confuses me. I think I can still meet my burden of proof with my other witnesses, but I did want to put that on the record.
It does look like I just got a communication. We'll go on a brief recess while I discuss that with the judge and see what the issue is. We're off the record. Probation officer, there was concern from the district court about the probation officer's records being public. And if you find that at the conclusion of the evidence that you have today that you are still going to request that probation officer to testify, we'll need to take a short recess to take that up. But at this time, I'd like to proceed with the witnesses that you have present in the case that you have.
Yes, Your Honor, my first witness would be Carol.
Do you have an opening statement?
Yes, Your Honor. This is the second case with this family. The facts in this case are exactly the same as in the first. We have two parents who are in a domestic relationship. It has been increasingly and more frequently violent since the start of the first case, which was also in front of this court. Despite this being the second case, the parents have become less engaged with services, and the father is currently in jail. And I believe the evidence will show that he is sitting in jail facing new domestic violence and a revocation of his probation for domestic violence. I believe there's evidence that a lot of these events occur in front of the children, and that the children are endangered not only from the emotional trauma of this relationship, but by it being in front of them. If adult probation were to testify, I believe it would show that the father is not in compliance with his criminal probation. He was not in compliance with the drug testing component, which this court ordered to be done.
Objection, Your Honor. But if she's actually saying she's not going to be able to present the evidence, or may not be able to present the evidence that she's now telling you in her opening, like all that's stricken from the record, Judge.
Your Honor, I believe that you just said that it could in fact be put in.
What I said was, if you find that the witness is going to be necessary, we'll take a recess to discuss that witness's appearance. So comment on that potential witness's testimony will be stricken from the record.
I believe the evidence will show, whether probation testifies or not, that he is facing jail time and a revocation, and he has spoken with the caseworker and shown no changes, no concept of how serious this is, and absolutely no intention to change the behavior patterns. At the end of this case, TFPS will be asking for termination of parental rights of both parents based on D, E, and O grounds, and perhaps P, depending on what the evidence presents. These parents have flagrantly disregarded this court's orders and failed to complete even the most basic of services.
Sorry, I don't have an opening, Judge.
All right, thank you. Mr. Betty, any opening remarks?
Waive the opening, Judge. Thank you.
Mr. Rios,
I'll waive the opening as well, Your Honor.
Ms. Levy, you may proceed with your first witness.
I'd call Carol
Ms.
Beimer. How are you connected with this case?
I was the CPS investigator assigned to the case.
And were you the investigator for just this case or for both cases?
Just this case
How long have you been a CPS investigator?
for 17 years.
What kind of training goes into being a CPS investigator?
Significant training to be able to determine if there's abuse or neglect going on, as well as being able to work with others in the community, such as law enforcement, to make sure children are safe.
How much annual training do you have to do to maintain your status as a CPS investigator?
It just depends. I don't know if there's necessarily an exact number, but it is highly encouraged.
Every year, would you say that you do at least 40 hours of training?
Definitely.
What was the intake that got you involved with this case?
We received a report on March the 2nd, 2022, regarding domestic violence issues between Esperanza and the father, Craig, that occurred in the previous month in February 2022. The report was also saying that Craig had not been drug testing for the CVS case concerning the other two children, and that Esperanza had tested positive for marijuana in that same month in February.
Now, in your 17 years as an investigator, is it standard to rely or consult a family's history in making your investigation?
We always look at history. Yes, ma'am.
And what kind of history did you find in this case?
There were a significant amount of police reports dealing with domestic violence between the two parents, some that were not even reported to CPS. And then, of course, there was also the ongoing case at that time with CVS regarding the two older children who had been removed because of domestic violence.
So at this time, when you get the intake, you see a pretty lengthy report, both in law enforcement and in a previous CPS case.
Yes, ma'am.
What did you do first in your response to this intake?
The first thing I did was attempt to speak to both parents at the apartment. I was able to lay eyes on Esperanza as well as the baby, but she would not come out to speak to me, and I wasn't allowed into the house by Craig.
Were you ever able to make contact with these parents?
We eventually had Esperanza come into the CPS office that day and speak to the CVS supervisor at the time. And then I was able to speak with Craig in person the following morning.
And what did you learn when you spoke with Mr. Funk?
He denied that there had been any domestic violence between them. He admitted, if I remember correctly, to being obviously in the home because I caught him there, but also being alone with the children, which was something that was asked of them to not happen.
And what did you do next?
We, at that time, needed to go back and staff with our law enforcement, with our legal department and my supervisors to determine what needed to happen next. There was a safety plan that was put in place, again, stating that Craig was not to have unsupervised contact with any of the children and that it was supposed to be supervised by CPS only.
And did something happen to where this wasn't the end of your involvement?
We, in the next few days, were not able to get a hold of Craig or of Esperanza, nor, of course, they had the baby with them. And eventually, the maternal aunt convinced Esperanza to come to her home where we were able to speak to mom and see Graceland. And that's when an emergency removal was done.
And what did Mr. Sendez tell you about the events in question?
She denied that she had been around Mr. Funk.
And just to clarify, he'd already admitted that they were together. Is that fair to say?
Correct, yes.
Okay.
She denied that, there had been any contact between them since the safety plan was put in place. But the aunt has surveillance cameras at her house, security cameras, and she did confirm that Craig was the one who dropped Esperanza off at her house, at the aunt's house, prior to the emergency removal.
Was there some information about how Graceland was transported to the aunt's house?
Yes, Esperanza admitted to having Graceland on her lap while they were driving around San Angelo instead of in a car seat.
Were you able to talk to the older children?
I was briefly. The oldest one was quite honest about everything and would admit to Craig being violent toward Esperanza, hitting her in the back of the head with a remote, hitting her head on the wall, pulling her hair, those sorts of things.
So the oldest child stated that she had seen physical altercations between the parents.
Correct.
And was that the end of your involvement with this case?
Yes.
Now, based on your training and experience, what are the dangers to children of being around domestic violence?
There's the obvious danger of them being hurt themselves, trying to get in the middle to help the non-offending parent, to accidentally be hit by something if something's being thrown. But then obviously there's also the concern of their emotional well-being as to them seeing a parent be beat up and hurt.
Based on your training and experience, do you believe that the acts of Mr. Funk and Mr. Sendez endangered Graceland, the infant?
Yes, ma'am.
And do you believe that those dangers are especially pronounced given her age?
Of course, yes.
Would your concern be heightened based on the fact that another CPS case had just finished?
Yes, ma'am.
I'll pass the witness.
Mr. Simons, questions?
No questions for this witness.
Mr. Betty, questions?
Question, Judge. Thank you.
Mr. Rios?
No questions, Your Honor.
Ms. Levy, any further questions for this witness?
No, Your Honor. May she be excused?
Any objection to excusing the witness?
No objection.
I would call Miss Williams. And how are you connected with this case?
I am the conservatorship worker.
Were you also the conservatorship worker for the first case?
Yes, I was.
What initiated the first case?
The first case was initiated due to domestic violence. At the time, they had been, the family had been referred to our family-based safety services program. There was another domestic violence incident, and that's when a removal occurred of the older two children.
Now, you heard me speak with Ms. Beimer about the importance of relying on case history in a CPS case. Is that accurate?
Yes, ma'am.
So in this case, were law enforcement records requested?
Yes, they were.
Your Honor, I would offer petitioner's exhibit number 4, which is the law enforcement records concerning Ms. Resendez and Mr. Funk. They are filed with a business record and have been served on the parties in the requisite amount of time.
Mr. Simons, any objection?
No objection. Sorry.
Mr. Betty?
No objection, Judge.
Mr. Rios?
No objection, Your Honor.
And it's marked petitioners 4, Ms. Levy.
Yes, ma'am.
Petitioners 4 will be admitted.
Ms. Williams, how far back do those law enforcement records go?
The ones that we have are dated back from, this one is 2020, March of 2020.
And have you reviewed these records?
Yes, I have.
What stands out to you about these records?
The majority of these reports do involve some type of assault between Ms. Resendez and Mr. Funk.
And would you agree with me that they seem to be occurring with increased history, increased frequency as we move closer to now? Like I'm sorry, Your Honor. Would you agree with me that they become more frequent as time goes on?
Yes, more frequent, as well as they have also appeared to be more violent, with even some of the most recent ones being having medics involved.
Your Honor, I would also offer petitioner's exhibit number 6, which is a certified copy of a waiver of indictment. And a charge for Mr. Funk from a 2015 offense. And the order of deferred adjudication for that injury to a child offense.
Any objection, Mr. Simons?
No objection.
Mr. Betty?
Objection.
Mr. Rios?
No objection, Your Honor.
Petitioner 6 will be admitted.
I would also like to offer petitioner's exhibit number 7, which is a certified copy of a possession of marijuana case against Mr. Funk from 2011. And Your Honor, I would also like to offer petitioner's exhibit number 8, which is a certified copy of a probated judgment against Mr. Funk, also for possession of marijuana. And petitioner's exhibit number 9, which I'm also offering, is a certified copy of the probated judgment for the 2015 offense.
What offense is that, Ms. Levy?
Criminal mischief.
So petitioner's 9 is a probated judgment of criminal mischief for which parent?
Mr. Funk. And Your Honor, I would offer petitioner's exhibit number 10, which is the complaint information, as well as the judgment and sentence for the 2020 assault family violence that Ms. Williams referenced earlier. Is the date of the complaint where he pushed Ms. Resendez against a car door. Now, Ms. Williams, this 2020 offense where Mr. Funk pushed Ms. Resendez against a car door, is that one of the ones that was used as the basis of the removal from the first case?
It very well could have been. I do not recall specifically all of the basis for being referred to the FBSS. I'm aware of the reason that the removal for the assault was for assault on a pregnant person.
Do you recall if Ms. Resendez had either of the older children with her during this 2020 assault?
I believe that they were, yes. I'm unsure exactly without reviewing it all.
Did the parents admit to you at any point in this case that the children were present during some of the assaults?
Yes, they have.
In Your Honor, I would like to offer petitioners exhibit number 11, which is a 2022 assault against Mr. Resendez by Mr. Funk, for which he was put on deferred adjudication. And Ms. Williams, referring to this 2022 case, and this is one of the ones that Ms. Weimer was speaking about, do you see this no contact order with victim on the magistrate's heading?
Yes, ma'am.
And so is it your understanding that Mr. Funk was to have no contact with Ms. Resendez essentially from 2022 to present?
Correct.
Now, we spoke briefly about the order in the previous case in which you were also the caseworker. What was the outcome of that case?
That case resulted in permanent managing conservator being granted to maternal grandparents with parents having possessory, but there were very strict outlined visitation guidelines for Mr. Funk, that he was not to have visitation unless it was within a third party, unless it was agreed upon. But Ms. Resendez did have visitation rights.
And I'm showing you what's been marked as petitioner's exhibit number 12. Do you recognize this document?
Yes, ma'am.
What is it?
It's the final order of judgment for the previous case or for the companion case.
And does it appear to have been altered or modified in any way, or is it a fair and accurate copy of that final judgment?
It's a fair and accurate copy.
Your Honor, I would offer petitioner's exhibit number 12, which is the final order from the previous conservatorship case. And Ms. Williams, why were the parents' rights limited in this way? Or why did the department request that their rights be limited?
We knew that the family, that the children would be with the family. So at that time, we did not request any type of termination, as we did not feel that they were necessarily even stating that they were together, because even the parents testified in that case that they were not together and that they were following all the conditions.
Okay. But at the same time, you obviously did not do a monitored return. So what concerns did you have at the conclusion of that case?
That there had been the continued issues of domestic violence, even after we did previously attempt a monitored return. At that point, Mr. Funk had also not been doing any type of services, and not having much contact. And Ms. Resendez was not really being able to express why the situation was going on versus just checking boxes instead of showing how she's made changes to be able to protect the children.
All right. So I'd like to switch gears and talk about this case in particular. Now, at the time it came in, the parents had just been given service plans and just been kind of failed to complete them fully. Is that fair to say?
Yes, ma'am.
And prior to that, there had been an FBSS case where they had been offered services in the home. Is that also fair to say?
Correct.
Now, were services offered in this case for a third time?
Yes, they were.
And did you do service plans for these parents?
Yes, I did.
I'm showing you what's been marked as petitioner's exhibit number 1. Do you recognize this document?
Yes.
What is it?
It is the family service plan for Craig Funk.
And is this a fair and accurate copy? So far as you know, it hasn't been altered in any way?
Correct.
Your Honor, I'd offer petitioner's exhibit number 1, which is a certified copy of the service plan filed in this case. Let me find. Ms. Williams, I'm also showing you what's been marked as petitioner's exhibit number 2. Do you recognize this document?
Yes, ma'am.
What is it?
It is the family plan of service for Esperanza Resendez.
And is it a fair and accurate copy of the family plan of service that you made?
Yes, ma'am.
And it hasn't been altered in any way?
No, ma'am.
Your Honor, I would offer petitioner's exhibit number 2, the family plan of service for Ms. Resendez.
Any objection, Mr. Simons,
No objection.
Mr. Betty,
No objection.
Mr. Rios?
No objection, Your Honor.
Petitioners 2 is admitted.
Now, Ms. Williams, were you able to go over these service plans with the parents?
Yes, I had.
So even though Ms. Resendez's is not signed, she was aware of the services being asked of her by this court or by
Yes.
CPS?
Yes, these were also the same services that were continuing on from the previous case. So we had been going over the services throughout both cases.
Your Honor, I would also like to offer petitioner's exhibit number 3, which is a copy of the status order from this case in which those family plans of service were made orders of this court. All right. So, Ms. Williams, let's start with Mr. Funk. What services were you asking him to complete?
We were asking him to obtain and maintain a safe, stable home environment, maintain a legal source of income, complete a parent support group virtually.
All right, let's slow down real quick. So the first one was safe and stable home.
Yes.
What progress did he make on that?
On this case, there was no progress, as any time that I was able to have contact with him, he would report that he was homeless and did not have anywhere that he was residing.
All right. And I believe you also said stable income. What progress did he make on that?
He did report an income on September 26, 2022 to me, that he was working, I believe at that time it was through People Ready, and was doing contract work.
Were you able to verify that employment?
He did send verification of that, yes.
And to your knowledge, is he still employed in that regard?
No, he is not. I don't know the last employment that he had. When I did speak with him recently at the jail, he had stated that he was supposed to start a new job. I believe it was the day after I spoke with him.
To your knowledge, is he still in jail?
Yes,
So is it likely that he is still unemployed?
correct.
What was the next service after stable housing and income?
Participate in a parent support group.
Did Mr. Funk complete that service?
For this case, he did not.
Did he tell you why he didn't complete it?
He did not. I had sent the information to him, but at that point, he was not responding to any of my messages.
Now, you stated he didn't do it for this case. Did he do it for the previous case?
He did do it for the previous case. However, we were requesting it again to be able to help provide him with more support and possibly more resources to help utilize.
Okay, and is it fair to say that if we're having the same problems, the service didn't take last time?
That would be fair.
So part of why we're asking him to do it again is because no habits, no behaviors have been changed.
Right.
What was the next service?
The next service was to sign a consent to release of confidential information.
And what was that release for?
We were requesting that he sign one with probation to be able to attempt to obtain copies of paperwork from them.
Okay, and was part of the reason for that in order to avoid duplicating services he was already doing with probation?
Correct. It was in a hearing that the court decided not to have him duplicate UAs or a BIP course. And so we wanted to be able to get those documentations to be able to have for this case.
Okay, and did he sign that release?
He did not. To my knowledge, probation has not had one on file.
Do you know if his probation if a motion to revoke has been filed in that case?
According to the public records online, yes, there is a motion to revoke on his probation.
So it's fair to say that he's likely not in compliance in some way or another with that probation.
Correct.
What was his next service?
His next service was to participate in visits as arranged by the department.
And did he participate in visits?
He did not, with the department's knowledge. He admitted to me when we did speak at the jail that he had been seeing the children outside of the visitation plan, as him and Ms. Resendez had been together. Once the plan was updated and everybody was made aware that visitations were only to occur through the department, shortly after he was arrested.
Do you think he was aware that he was not supposed to be visiting outside of the CPS supervised visits?
Yes, at the time, even at one point during when he was first released, he had even contacted me about visitations and wanting to get those set up, wanting permission to travel with Ms. Resendez to the visits, which I explained he would not be allowed to do due to the no contact. But he did not speak further to me about trying to get any of those arranged. And at the time, the caregivers were living in Dalhart, which made it a little bit more difficult. Since they've been here, he has not reached out for any type of visitation.
And you heard Ms. Weimer talk about setting up a safety plan during the investigation phase. Is that accurate?
Yes.
And you saw the court documents that had a no contact order. So
Correct.
it's fair to say that even though you just said we had to go back and talk to them again about visitation, both Ms. Resendez and Mr. Funk knew that they were violating this court's orders and the criminal court's orders.
Correct.
All right. What was the next service asked of him?
The next one was to resolve any outstanding legal issues that he had, which was that he had been recently arrested for a domestic violence issue that he is currently on probation for.
And you previously stated that he is currently in jail. So did he resolve those?
No, he's actually was arrested for a new charge for assault, and that is what got him arrested again, and then the motion to revoke for probation for the prior charge.
Okay, now I'd like to come back to that and talk about it once we finish talking about services. So we'll circle back to that. What other services were asked of him?
To maintain contact with the department.
And has he done that?
He was not maintaining regular contact. He had contact, the last was September 21st of 2022. And then there was no contact able to be made with him until January 11th of 2023 after he was arrested, and I was able to meet with him at the jail.
All right, now we've already talked about how there were successive FBSS cases and then 2 conservatorship cases. So do you believe Mr. Funk knows how to reach you?
Yes.
Do you believe that the contact information you have for him is accurate?
The time he did not provide any other documentation to me saying that he had other contact information. So I only had a cell phone number that he had reached out to me on, as well as I had an email address that he had corresponded with me.
Okay, but he had responded to both of these modes of communication in the past.
Yes.
So if he wanted to reach out and maintain contact, he could have.
Correct.
And did you maintain contact? Did you continue to reach out through that phone number and that email address?
I attempted to send text messages to be able to try to meet with him to speak about the case, and would not get any type of response from him.
What was the next service?
He was to do individual counseling.
And did he do that?
He did not. He was set up for a initial meeting. The provider has informed me that he showed up because the provider is from out of town. They travel. They were not there at the exact time that Mr. Funk showed up early, but was there in time for his meeting. But Mr. Funk did not stay around and left, and has continued. Even when I spoke with him last month about that, blames the counselor for not being able to do that service.
And what else was on Mr. Funk's service plan?
That was all of his services.
Okay, now we talked about substance abuse and batterer's intervention. What was he supposed to do to take care of those requirements?
He was utilizing those services through probation.
Okay, and did he provide you with any evidence that he was in compliance with those?
No, he did not. And when I did speak with him on January 11th and asked him about his services, he did tell me that he did not do the BIP course as he had already completed that and didn't feel a need to complete it again. I tried to speak with him about this time it was different, that it would be with an actual instructor and in person and not just reading through and writing a paper. But he was adamant that he had already completed it. As far as the UAs, we did not ever speak about those.
Okay, and again, there were several domestic violence incidents between the first time he did BIP and when we were asking him to do it this time. Is that fair to say?
That's correct.
And it was still an order of this court, even if it was to be done through probation. Is that also fair to say?
Yes.
Why was he asked to do drug testing?
During the previous case, he had been testing positive for marijuana. He would only state that it was from using a vape pen. He had admitted when I completed an original FSNA with him that he had drug issues in the past. And so we were trying to stay on top of that to ensure that that was not a cause of what could cause issues within the home to start domestics.
Okay. Now, would you say that Mr. Funk has complied with even a single one of his services?
No, ma'am.
All right, let's switch gears and talk about Ms. Resendez. What was she asked to do for services?
She was asked to maintain a safe and stable home environment and allow visits into the home.
Did she do that?
She did have housing. The last time I was able to get in the house and visit with her was August 18th of 2022. Since then, she would not allow any type of visits in the home. I tried unannounced visits to the home when her vehicle was there and was unable to get in. The last contact that I had with her at the residence was December 27th of 2022. When myself and a special investigator went to the home, she was found to be inside the home and stated that she was not willing to work any other services for the department.
Now, on that December 27th visit,
Or it may have been the 29th, I'm sorry.
did you see anything at that visit that alarmed you?
Yes, as myself and the special investigator did pull up to the home, Ms. Resendez's vehicle was parked outside in the driveway. We both noticed that we saw a back window that was smashed out. As we continued to pull to the home and park and walk up to the home, we noticed that just about every vehicle or every window in the vehicle was either smashed or cracked open.
Okay, I'm showing you what's been marked as petitioner's exhibit number 5. Are these photos familiar to you?
Yes, those are photos that I took on the December 27th home visit.
And are these fair and accurate reflections of how Ms. Resendez's car looked on that date?
Yes.
They have not been altered in any way?
No, ma'am.
Your Honor, I would offer petitioner's exhibit number 5.
Any objection, Mr. Simons?
No objection.
Mr. Betty?
No objection.
Mr. Rios?
No objection, Your Honor.
Petitioner's 5 will be admitted.
Now, Ms. Williams, were you able to talk with Ms. Resendez about the car?
No, she would have no communication with us. She questioned why we were even there at the home and wanted me off of her property.
Were the children present at that time?
They were.
Were the children supposed to be present at that time?
No, they were not supposed to be there.
And do you have any way of verifying whether the children were present when her car was vandalized?
I do not.
Did you speak with the caregiver about the fact that this was a violation of our visitation plans for the children to be present?
Yes, I did speak
Show
with
to
him
the home
to take the children, and I expressed to him that the child was not to be at the home unless CPS was there, that she was to have no contact with the children or visitation with the children unless it was CPS. He did state that we had no control over the older two children as we had been removed from that case, which I explained that it was all a concern seeing a vehicle like that, not knowing what was going on, but that we did still have custody of Gracelyn and that she was not to be at that home.
Do you know if Mr. Funk was present at that time?
Mr. Funk has admitted to me when I met with him at the jail that he was there at the home at that time.
And similarly, was Mr. Funk supposed to be there?
No, he was not.
And we've talked about safety plans in this case and a no contact order from the criminal case. Did Mr. Funk tell you how long he had been in that home?
He did not tell me how long that specific time. He reported that he was not living there, but that he would be there frequently, as that they were trying to make their family work, and then placed blame on, he would not really speak about it further, as everybody breaks rules and laws, and he would only have a conversation with me about it if I could look him square in the eye and tell him I've never broken a law or a rule.
Okay, so he did admit to you that during the course of this case, when those no contact orders were in place, they were in a romantic relationship.
Yes, he admitted that they had been together since his release back in June of 2022.
And were they upfront about this during the course of the case?
No, they were not.
It only came out after his arrest at the beginning of 2023.
Correct.
All right, so we talked about housing. Would you say that if we have a vandalized car and a violent partner, would you call that safe and stable housing?
No, and even if it was not Mr. Funk who did that, if it was another individual, as they are telling me, or he told me, as well as the caregivers told me, it's still a concern that somebody around the home has been violent.
What else was on Mr. Sendez's service phone?
To maintain a legal source of income.
And has she?
The last I'm able to state is that she was verified with me employment on August the 8th of 2022. I have not been able to get any other type of verification since that time.
And is that due to her lack of cooperation with the department?
Yes.
All right, what else is on her service plan?
To participate in individual counseling.
And has she?
She was continuing up until December 15th of 2022. She was discharged from Angel Flores due to no call, no show. Since this was not the first instance, he's unable to continue to be able to see her.
And what else was on her service plan?
To maintain contact with the department.
And you've already kind of mentioned this, but has she done that?
She has not. So I did have contact December 27th when I went to the home when she was not willing to speak with me. Prior to that, I did have contact November 28th, but that was only messages telling me that she did not have time to meet with me after she had told me to go F off, but that she used the full word.
And what else was on her service plan?
To participate in visits.
And we already talked about the violations of the safety plan. Has she participated in visits through the safety plan?
No, so since the visitation plan was updated January 9th, she has not contacted for any type of visitation.
Do you know if she is seeing the child at the caregiver's home without CPS's knowledge?
The caregivers continue to report that she is not, but I'm unable to confirm that. I'm just having to go off of what's reported to me.
And what else is on Mr. Sendez's service plan?
To submit to random drug testing as requested.
Has she done that?
The last was September 28th of 2022. When I did speak, just asked her on December 27th if she would be willing to drug test. She stated no.
Okay. And were there any other services?
She was to do domestic violence classes, which she did complete October 17th of 2022. And that was verified with the workers at the family shelter. And then we did add for her to complete a parent support group virtually, but that was not able to be completed due to her not wanting to have contact with me. But I did mail her the flyer with the information to be able to try to get on that.
And were those the only services on her service plan?
Yes, ma'am.
So would you say at this time that Ms. Resendez is in compliance?
At this time, I cannot say that she is.
What happened? What knowledge do you have of why Mr. Funk is in jail presently?
That there was an assault on, I believe it was January the 9th of 2023 that he was arrested for at the residence of Ms. Resendez.
And what did you have a chance to ask him about this event?
We briefly spoke about it on January the 11th.
And did he admit that he was in the home?
He admitted he was there at the home. He, again, will not admit that that there was an issue with being at the home, even though there was a no contact order. But he did admit being there.
And did he admit that there was some kind of fight between him and Ms. Resendez?
Yes, he admitted that they did get into an altercation.
And has Ms. Resendez ever discussed the violence with you?
No.
At the hearing to revoke the monitored return of the older children, did she admit to being hit in the head by Mr. Funk?
At one point she did. I'm not sure if that was at the time of the motion to revoke or if it was after, but she did admit to me that he had hit her in the back of the head with a remote.
Okay. So we have children telling us that they've seen it, and we have both parents to some degree owning up to the fighting in this relationship.
Yes.
What do you believe is in Graceland's best interest?
To be able to remain with her grandparents and not be involved with the parents that are involved or having domestic relationship issues.
So we've talked about kind of the increased violence and the increased lack of cooperation. Have you been able to observe Graceland with her grandparents?
Yes, I have.
And is she bonded to them?
She is very bonded to them. She has, as she started speaking and growing, she called their mom and dad to her. She's always happy and smiling when she's being held by her grandmother. But she appears to be very happy there, as well as being with her older sisters.
And is that, for all intents and purposes, the only home she's really known?
Yes.
Do you have any reason to believe that these parents are going to make any type of changes to be the safe and stable parents that Graceland needs?
Based on the history within the two cases that I've worked with them, no.
Now, it's fair to say that we have some concerns with the grandparents' protective capacity. Is that also fair to say?
There has been some, yes.
Can you explain to this court why, despite that, you believe that termination and adoption by those grandparents is in Graceland's best interest?
They would not be able to adopt as they're not able to be licensed, but to be able to remain in the home, because that is the home that she has seen. I have specifically spoken with the grandparents about the issues with domestic violence, what it can cause within a young child, being physically hurt, emotionally and mentally, what it can do to them, and that we need to be able to protect Graceland at all costs and not have her involved in that.
Your Honor, I'll pass the witness.
Mr. Simons, any questions?
I don't have any questions, Judge.
Mr. Betty, any questions?
No questions, Judge.
Mr. Rios?
No questions, Your Honor.
All right. Ms. Levy, any further witnesses?
No, Your Honor, the state would rest.
All right. Mr. Simons, any witnesses at this time?
No, ma'am.
Are you resting?
I am.
Mr. Betty, any witnesses?
No witnesses, no close, resting, Judge.
All right. Mr. Rios? any
No
wit-
witnesses, Your Honor.
All right. Do you rest and close?
Yes, Your Honor.
And as the guardian ad litem for the child as well, having heard the evidence in the case, do you now have an opinion about best interest?
I do, Your Honor. In my best interest, it is that the child remain where the child is. I think these parents have had more than ample opportunity to get their lives together, and here we are today. One in jail, the other one not even making contact with the department. We've talked to them several times, attempted to do everything to see if we can reconcile them with their children. They have not stepped up at all. So I think it's in the best interest that the child remain there with her other siblings, and that I totally agree with CPS in this matter. Thank you.
Thank you, Mr. Rios. All the parties resting and closing. Ms. Levy, do you have any closing remarks at this time?
Your Honor, I think the evidence is very clear. These parents have disregarded the orders of this court, the orders of the criminal court, despite the fact that the violence seems to be increasing both in frequency and in intensity. They are continuing to expose their children to it and are refusing help. I think that these grandparents need some kind of serious orders to keep the children away from these unsafe situations. So we are asking at this time that the court grant the termination under D, E, and O grounds for both parents.
Mr. Simons, any closing remarks?
No closing.
And Mr. Betty, you previously said you were waiving closing. Are you waiving
No
closing?
close, Judge. No
All
close,
right.
thank you.
All right, we're going to take maybe a 2-minute recess and the court will be right back. We'll be off the record. Having heard the evidence in the case and accepted the exhibits and reviewed the same, finds that it has jurisdiction to hear the case if the parents were properly served and notified of this final hearing. I further find by clear and convincing evidence when it comes to Mr. Craig Funk that grounds do exist in that he knowingly placed or knowingly allowed the child to remain in conditions or surroundings which endangered the physical or emotional well-being of the child, that Mr. Craig Funk engaged in conduct or knowingly placed the child with persons who engaged in conduct which endangered the physical or emotional well-being of the child, and further that Mr. Craig Funk failed to comply with the provisions of a court order that specifically established the actions necessary for the parent to obtain the return of the child who's been in the permanent or temporary managing conservatorship of the department for not less than 9 months as a result of the child's removal from the parent under Texas Family Code Chapter 262 for the abuse or neglect of the child. I find that those grounds exist by clear and convincing evidence. I further find that it is in the best interest of Gracelyn Funk to have Mr. Craig Funk's parental rights terminated. There is no plan and was no plan presented on behalf of Mr. Funk about his future with this child, how he's going to maintain any stability for the child. But there was evidence that she is currently in a safe and appropriate placement with her grandparents, intended to be permanent with her siblings. She's bonded to them and calls them mom and dad. For those reasons, I find that it is both grounds exist and that it is in the best interest of Craig Funk's parental rights be terminated. When it comes to Esperanza Resendez, I find by clear and convincing evidence that she knowingly placed or knowingly allowed the child to remain in conditions or surroundings which endangered the physical or emotional well-being of the child. I find that Esperanza Resendez engaged in conduct or knowingly placed the child with persons who engaged in conduct which endangered the physical or emotional well-being of the child. I further find that Esperanza Resendez failed to comply with the provisions of a court order that specifically established the actions necessary for the parent to obtain the return of the child who has been in the permanent or temporary managing conservatorship of the department for not less than 9 months, and as a result of the child's removal from that parent under Texas Family Code Chapter 262 for the abuse or neglect of the child. I further find by clear and convincing evidence that it is in the best interest of the child to terminate Ms. Resendez's parental rights for the reasons previously mentioned, that she's with her siblings and her grandparent, that she is bonded to them and they have a plan for her future. I find that both parents' rights should be terminated. I find that by clear and convincing grounds. I find that there is no evidence that the child was removed from either parent based on the fact that she was homeschooled, was economically disadvantaged, that they had committed a nonviolent misdemeanor other than the offensive assault, that the child had been provided a low dose of THC for treatment, that they had been declined immunizations for reasons of conscience, including a religious belief, or that the child was engaged in normal activities for her age, ability, and culture. I further find that there's been no affirmative evidence that the parents could not complete the services through no fault of their own. Having found that those conditions do not exist, I terminate the parental rights of both Esperanza Resendez and Craig Funk. I will name the department as the permanent managing conservator over the child while the permanency plans for the future are finalized. Mr. Rios, since I named the department the permanent managing conservator, I am going to retain you on as the ad litem for the child. I do appreciate that you have a good relationship with these grandparents and are able to ensure that these children are being taken care of. So I'm going to maintain you as the attorney and guardian ad litem while she is in the managing conservatorship of the department. Are there any questions or clarifications about what I've done today, Ms. Levy?
Yes, Your Honor. The department was requesting, and I apologize if I wasn't clear, that Ramon be named the managing conservators because we do not believe that they can be licensed for adoption. Is the court amenable to that or denying that?
We're going to have our next hearing on May 17th, 2023 at 2 p.m. And that will be a virtual hearing, and I will take that matter up at that time. And as far as the other two attorneys, you will need to appear at that setting. Any other questions or clarifications, Ms. Levy?
No, Your Honor.
Mr. Simons?
No, ma'am. Thank you.
Mr. Betty?
No, Your Honor. Thank you.
Mr. Rios?
No, Your Honor.
All right. Thank you all, and we are adjourned.